Hello everyone, this is Sachin Sawant, your UK immigration lawyer. Currently I am live. Sorry about the delays. I was trying to set up OBS studio. Okay, so there are many comments on the channel now. So to begin with, what I will do is try to do a random number generation and try to answer any questions. Sorry about the delay. Yeah, I have started the live now. All the live questions, and there are comments as well. Anyone who wants immediate answers, you will have to send a super chat. Those are the only ones that will be prioritized during the live. Uh, but for others, I have to mix up the live comments as well as the comments on the channel, and I will do a random number generation and answer the comments accordingly. I want to do justice to everyone. So these are the comments on the channel. Let me just do a count, and then how many are they? 5, 6. 7, 8, 9, 10, 14, 24, 6, 6, 6, 7, 8, 84 plus. Okay, and I have 1, 2, 3 live comments plus I will answer Shamik's questions. Okay, Shamik, briefly, you are a member, so I will prioritize your question first. Can I switch solely from a skilled worker visa to an ICT dependent visa from inside the UK without the intervention of the primary ICT visa employer? Yes, you don't need anything from TCS, the ICT sponsor. You can sponsor, you can apply on your own behalf. You don't even need to inform the sponsor of your wife. So that is perfectly fine. Next question. Consider a primary visa holder present in the UK with a valid course. Yeah. So assuming that you can apply from inside the UK and become a dependent, switch from skilled worker. I think you lost your job last time you asked something about that, or you can switch to becoming a dependent from inside the UK. TCS does not need to know or do anything about this. Okay, so I have about 84 plus 1, 2 and 3. Thanks, Shamik. Okay, so plus 3. I'll do a random number generation. I have the number 87 here. So 1 to 87. Generate number 15. Okay. Where are the comments? Okay, so I have 1, 2, 3, 6. Down 7, 8, 9, 10, 11, 12, 14, 15. Okay. Question from Akia Khan. Assalamu alaikum. Can you tell me, my sister-in-law is in the UK. She made fake wage slips. Her husband is in Pakistan. They submitted their documents for spouse visa. Will this fake pay slips cause any problem? The comment from Akia Khan is on the financial requirement. I think that's what you're asking about, of the spouse visa. I would advise against using any fake pay slips. To the best of my understanding, I know Home Office will do the search on the NI number, because I know I have had cases in the past, maybe 5, 6 years back, when even the employer did not pay the individual had pay slips, but the employer did not pay the taxes to the HMRC, and they still did refuse that application as well. The applicant did not know anything about this. So in your case, if the pay slips are fake, I am quite positive Home Office will find it out and the application will be refused. So I would advise anyone against using any fake pay slips or anything like that. They would definitely do an HMRC check on the NI number and see about what taxes are paid, what income is being reported by the employer, etc. So that is my answer. So next question. I still have 87. Let's generate another one. Number 82. So I had 84. So Go to the bottom. 84, 83, 82. Okay, user ON8JR. The question is, hello sir, I am on a skilled visa in care home. My company license got removed. I want to change my sponsorship. After changing sponsorship, can I bring my dependent to join me in the UK after rules apply? Okay, so the question is from someone who already has a care worker visa. Their employer sponsor license is being revoked or suspended, whatever the status is. So you want to change your employer, and your question is, can you bring your dependent? Since you entered the care worker, skilled worker area before the rule changes on 11th March, yesterday, you can still bring your dependents after you change to the new employer, or even when you're working. I think your employer has already lost license. So once you change employer, you get the new skilled worker visa with your new employer, then you can bring your dependents, because you still come under the old rules. The new rules will not apply to you because you entered the skilled worker area before the change of the rules of 11th March. Okay, so next, let me mark this one as done. Okay, so just to clarify, anyone who is live, if you want immediate answers, you'll have to send a super chat or become a member. So I think Shamik asked this question. He's a member, and we would answer those questions, prioritize those questions. Anyone else, I have to do justice. There are 84 questions on the channel, which you can see on the screen, which I'm sharing. I will total up with the live questions, and I'm doing a random number generation over here, and that's how I'm getting to the comments and answering them randomly. So whoever is lucky enough will get their questions answered. Next is number 62. Okay, 62. 62 would be 6 tens are 2, 3, 4, 5, 6, 7, 8, 9, 10. Okay. Okay. So 62. Why did I count it wrong? Let us see. 1, 2, 3, 4, 5. 11 into 6, 66. 3, 1, 2, 3, 4, 5. Let's take 66 plus 6, 72. Okay, 72. 38. 6, 6 are 36. Okay. 1, 2. 36 and 38. 1 and 2. Okay, user F. Dear sir, I have ILR under the 10 years rule. My ILR BRP is getting expired this month. Will be 10 years on the card, so it's about to be expired. Do I need to renew it? The BRP card. So all the BRPs, just to give an update on that, all the BRPs will be phased out. There will be no more BRPs issued after 31st December 2024. After that, there will be a digital system, digital by default. That's why the Home Office calls it. So if your BRP is expiring today, for example, you have ILR and today is 12th March, today is the BRP expiring, you would only need to, if you are planning to travel outside the UK and come back, so that if that is your plan, if you are going outside the UK and then you would want to come back to the UK, you will have to apply for a BRP for your ILR. So you will have to get a BRP for the ILR. The ILR period is unlimited. Only the BRP period was 10 years, because at that time, I remember 10 years ago, they were issuing, the goal was to phase out the BRPs, hence they were issuing 10 years BRPs, and then they reduced it to 5 years and all of that. So if your BRP is expiring, you should apply only if you want to travel outside the UK Inside the UK, the problem will be if you are changing employers or you are doing a right to work, right to rent, any of those right to checks, then you would need a BRP. Other than that, if you don't have any travel plans or changing jobs or changing your house or anything like that, if any so checks are not going to be done, then I don't think you need to apply. You can wait for the digital system to come. Home Office has not clarified on this yet. We have raised this whether BRP is expired. Do they need to apply again for a BRP? So at this stage, to the best, what I would suggest is yes, you should apply for an extension. Home Office is not very clear. Sometimes they are saying that you may have to apply for a new BRP and then go into the digital system. So it's not very clear. We've asked Home Office whether individuals should use their passports or their BRP cards to open that UKBI account whenever that starts, around April or something it may start, I think. So my advice for you is simple answer, yes, you should apply for a new BRP card. Okay. Okay, let's random number generation. Okay, let me add one more here, 3, 7, 1, 2, 3, 4, 5, 6, and 7 is here. Okay, question from Anchal Jakar. Will Home Office send an email to the employee or the employer to notify this cancellation? So the question is on the lost your job and the cancellation email that comes from Home Office, or is there any other way to check? So the notification email is ideally, as per the rules, Home Office should send it to the employee, because the employee has the visa. Home Office wants to cancel it, they have to send it to the employee and tell them your visa is curtailed, cancelled, whatever that is. But in practice, it may happen weirdly. I remember last year, some of the lawyers that I discussed with had reported sometimes the sponsor, authorizing officer got an email of that visa cancellation of one of their employees. Those weird things happen. There was also a lot where many sponsors got those automated emails cancelling many of the skilled workers BRPs or cancellation emails, but that was because of some system error. So a lot of system errors happen. The best way to check, or is it best to check with the employer to let the person know whenever they receive any such information? Yeah, you should look out for emails from Home Office in your own email. That would be the latest email that you used for your previous application. If you ended up using your maybe your representative's email or your employer's email, the cancellation email will also go there, because the way it works is on the Home Office system. I think on the video I have shared the screen of sponsor management system, how the reporting is done. On the reporting, the employer goes into the system, into the costs reporting for the migrant. They do select the option, I'm no longer continuing to sponsor this migrant, and they also put last known address. That is where ideally Home Office sends. There is an email option also, but it is an optional to the best of my knowledge. But in the past, I remember the physical letters would come to that particular address. But for now, I think Home Office is sending it by emails. It should come to the email that the Home Office has on record from your past application, from the latest application, and also check with your employer. The other way to check is you can go on to generate a share code as you are giving it to your employer or something. You go into the digital system and you see if your leave is cancelled, it will have the current date. For example, if your permission was valid for next 2 years, you lost your job and your cancellation email 60-day notice ends on say 31st of May. So on that digital system, when you use your BRP card and you do the right to work check or right to rent check, whatever check you do, the system will show you if Home Office has cancelled your visa and given you 60 days. If you are not sure a notice has come or not, you don't know anything about it, you may have to go into that system and see. It says over there the date will be reduced to 31st of May instead of 2 years in future. Let's say it was ending on 31st December 2025. You will see the new date. Your permission is going to expire on 31st May 2024. That's what you will see. That is the best way to check. That's how we also check if there is no clarity as to the letter is received or not. So once the cancellation letter is issued, the system automatically flips and puts that new date over there on the digital system. So okay, let me take another one. This one is done. 74. So anyone who is coming live, just to let everyone know, if you need immediate answers, you'll have to send a super chat during the live, or else the way I'm working today is there are a lot of questions on the channel which you can see on the screen. I've totaled this with the live questions also over here, and I'm using a random number generator, and whoever is lucky, they will get their questions answered. So number 7 was done. Let's generate 18, 9, 10, 11, 13, 14, 15, 16, 17, 18. Okay. Next question from Amina Khan 89. As a new entrant, can a person be sponsored for 5 years, or it can only be max 4 years allowed? As a new entrant, if you are switching from a student visa to a new entrant category skilled worker visa, you can get a maximum of 4 years of skilled worker visa. If you are switching from a graduate route visa into the new entrant category, then you can get a maximum of 2 years of skilled worker visa initially. I'm talking of initially. You can extend it afterwards, but at that time the new entrant benefit will not be there. Employer will have to give the regular salaries at that point of time. So that is my answer. As a new entrant, if you are switching from graduate route, you will only get up to maximum of 2 years. So there is a different logic that Home Office works with anytime. So let's say a student is out of studies and he is new to the labor force or the market. 4 years is considered as a reasonable period where the person becomes experienced or to be able to get a normal salary. Hence, if you are a student, you get up to 4 years of new entrant category visa if you are switching directly from being a student. If you are switching from a graduate route, the 2 years that your permission was given, and it depends on permission, it doesn't depend how much you have used it. So if you have already got a 2-year graduate permission and then you decide to switch, you will only get up to a maximum of 2 years of new entrant category visa. So this is marked. Okay, no more live questions. Okay, 64. Okay, 1, 2, 3, 4. Let's take this one. Is it legal? Okay, win with English. Is it legal that submit visa application until we get the course reply? Is it legal? It's not a matter of legal or illegal. It's a matter of validity of application. So if you submit as per the immigration rules, in practice what happens may or may not may be different, but as per the immigration rules, it is legal to file an application without any document rather. So it's not a matter of legal. It's a matter of whether it is a valid application or not, whether it will be considered for a decision or it will be just rejected without even looking into the merits of the application. So that is the question that need to be asked, whether it is a valid application to submit the skilled worker or care worker application until we get the cost, so pending a certificate of sponsorship. As per the immigration rules, it is by default, it is not a valid application. The immigration rules for skilled worker visa clearly state that with the application, no doubt, so there are separate different validity requirements. You should give a copy of your passport, you should pay the immigration surcharge, you should pay the visa fees. One of them in that list is also that you should give a valid certificate of sponsorship issued within the last 3 months from the date of application. So strictly speaking, no, it is not a valid application. In practice, something else may happen. They may keep on hold or all. But if you are trying to do it with the care worker visa, it is highly unlikely. It's anyways, the day has passed, so I don't think I should spend more time discussing about it. Anyways, so let's mark this one. And someone is also answering a submit application. The application need to be cost of submit. Okay, I'm not sure what that means. Fine. Let us see. Next question. Okay, how many comments do I have? 61 plus 1, 2, 3, 4, 5, 6, 7, 768. Okay. Number 16. Okay, 6 2s are 12, 12, 13, 14, 15, 16. Okay, my BRP card got expired November 2023. Can I renew my visa? I'm not sure what you really mean by that. The question that you asked is, how do I apply for graduate route visa if I have lost my student visa BRP? So that was the video which student visa BRP lost. You can still apply for graduate route. Okay, my BRP got expired 23. I'm not sure what you mean. If your BRP has expired, maybe your permission is also expired if you are on a student route or graduate route, either ways, because that is the video that you have questioned on. I'm not sure. I don't think you have valid permission. If your student BRP has expired, it has expired. There is nothing that you can do. You may not be able to file any applications when you are out of time. So if that is not the right question that you're trying to ask, you can write another comment and clarify the question, but that's how I understand it. Next, 51. Six, 7, 8, 9, 10. Okay. Can you please reply me that if we get salary of 37,000 and extra 5,000 for markup, will it be enough? Extra 5,000 markup, will they be added for the wages for new skilled worker visa? Markup. Okay, the question is on the increase for the salary requirement, which is going to increase for the skilled worker salaries. Minimum salary is going to increase from 26,200 to 38,700. The question is on that video. If you get the salary and extra 5,000 markup, I don't understand what that markup means. The way the Home Office looks at it is, it doesn't matter what you call it. You can call it guaranteed allowance or whatever the hell the employer may call it. But the fixed salary that is being shown in your certificate of sponsorship, your contract of employment, and the annual salary that is used to calculate, which is a fixed component. It cannot vary. The whatever you call it, markup or anything, that really doesn't matter. But that should be a fixed salary, a guaranteed salary of minimum of 38,700. Only then it will be considered. So that's how it means for that particular rule. So just 1 minute, checking something. I will be right back. I am checking on something. 1 minute. Okay. If you are a member, we will prioritize your question, or if you want your questions to be answered, prioritized, then you have to send a super chat. Those will be prioritized. Or if you are a member, and members usually are shown with a star mark or something, so please clarify if I have missed any members. I know Shamik Rakshit's questions I have answered. So the way the today's live is working is there are a lot of questions on the channel which you will see on this. I'm scrolling, and also there are several live questions. So I'm going to mix the number, and through a random number generator I'm trying to generate numbers and answer whichever ones I get selected on those numbers. So whoever is lucky will get their questions answered. If there is urgency, maybe consider becoming a member or send a super chat. So okay, 1 2 3 4 5 plus So there are how many of them now? 61, 71. Next number is 12. 1, 6, page down. 4, 5, 6. Okay, next question from Mohammed. And sir, how many working days can I expect a decision on my file? I'm not sure what your file you are referring to, but the question that you asked in, can I apply for a UK skilled worker visa without a cost? If you're applying from inside the UK, only then that without cost thing would apply, that video would apply. Outside UK, I would advise against applying without a cost, number one. Number two, how many days? It depends on what service you have used. The standard service, I think it is usually 8 weeks inside the UK. And there are some priority and super priority services. Super priority is 5 working days and super priority is 24 hours and priority services 5 working days. So those are the options that you may have. If that is not what you are asking, you can write another comment and ask the question again, but that's what I understand. 31. Okay, let's go to 31. 6 5s are 30. 2, 3, 4, 5, 6, 30. Okay, here it is. Next question from Oni Stephen. Thank you very much for answering my previous question. Thank you, Oni Stephen, about the start date. My case is that my current dependent visa would expire December 24. Okay, if my employer make the start date to be January 24, okay, can I still apply for the work visa this month, March 2024? No, I don't think you can do that. If you want to apply in March, your start, so the maximum you can delay is I think 6 months, because your course will only be valid for 3 months, and on the course also you can put a work start date of up to next 3 months in future. So sometimes something around 6 months in the future, up to 6 months, it may be able to be deferred. Work start date 3 months in future, and course is valid for 3 months. 3 plus 3 6. So maybe if you apply in March, April, May, June, July, August, September. So maybe August or September is the latest you can defer the start date up to, not next year. That is not possible. Okay. So several live questions. Let me count. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 13. 474. Okay, I see that there are some live questions as well. So I'm totaling the live questions with the questions over here. I'm doing a random number generator, and that's how I'm getting my numbers. Total is 74 now, 67. Okay. What is the number? 67. Okay. Okay, I'll just do, there are many questions on the live. I'll just do a random number generation for the live in between. Okay, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 12. Okay, let's do 1 to 13. Number 13, that's the last question. So now you are very lucky, just got the random number generation. Okay, so now this is the live question that I am answering. I have just done a random number generator of the 13 questions that are asked. I am a student dependent. My husband studied, not finished yet. I applied a care worker visa. Student dependent, husband did not finish. Okay, I applied care worker visa 21st of February with 1 year course inside UK, 1 year course. Standard service, but still no update. 21st of February and standard service. The standard decision processing time is 6 to 8 weeks for a skilled worker or a care worker visa. So you will have to wait for that period. I'm pretty sure it's only just under a month now. You will have to wait for 6 to 8 weeks for a decision under the standard service. Okay. I will go back to my comments and generate a number over there now. So this one is answered. Let's do. Okay, that one is answered. How many comments do I have? 1, 2, 3. It is 66, 10 and 1, 61. 61 plus, let us do the live as well. So 13, 3, 14, 15, 16. 76. Number 50. 12. 1, 2, 3, 50. This one is answered. Okay, let me take Valentine's question. So Valencia UAQ, your question is, dear Sachin, thank you for your videos. I'm an assistant professor at a university in the UK. I hold a skilled worker visa, remarks restricted work. I want to start selling my services as a facilitator for companies on the side. Do you know if it's possible for me to do that? Who could give advice on this topic? Yeah, so skilled workers doing other gigs. This is a common question that I always get on channel and various consultations also I do with clients. So the way the home office cares is if you are working for your employer, let's say you are contracted for 37.5 hours working week, that is what they care about on one side of things. So you should definitely work that much. If you do any other gig, what format you do it doesn't matter, whether you open a company, you are working somewhere else, whatever that is. If you are not spending that much contracted hours with your main sponsor, then home office would have an issue that may create issues with your extension or ILR or whatever that is, if home office becomes aware of that. How they would become aware, I cannot comment on that. I don't know about that. They may do an HMRC run. They do, anyways, they check the NI numbers and all of that to check the salary payments, tax payments, etc. So if they find something on your record, something registered and all. So other than that, if you are working in your own with the main sponsor, also on the skilled worker visa, I'll open it over here just to give an idea. There are many questions on this topic usually. So if you see over here what you can do with the skilled worker visa, this is, I'm not going into the immigration rules, just briefly on the top of it. So work in an eligible occupied job, take additional work. So with the additional work, they have specifically described what additional work you can do over here. Doing other things than these, so that's where your area comes. Let me see if it covers any of that. You work overtime in the job, you are being sponsored, you don't need to update. Okay, no limit. You can work 20 hours in a week in another job. You must be either same occupation code or occupation code. Okay, I understand this. So this is what the Home Office says. In my opinion, doing any other gigs, being sponsored on a skilled worker visa, you are just risking it. Even if it is 1% chance at the point of ILR or something, if Home Office finds something on your record, some income generated somewhere or something they find out, some company registration, or there are different connections between HMRC, company's house, UKVI and all of that. You are unnecessarily risking your own ILR or further immigration status in the UK. So I would advise against it. That is what my advice is. Okay. Okay, thank you, Suna. Fine. Okay, anyone who is coming live and asking questions, so if you want your questions answered immediately, I've answered the members' questions which have been asked at the top first by Rakshamik, I think, and anyone who is sending a super chat or they are a member, their questions will be prioritized and they don't come a part of this random number generation. Others, I have to treat everyone equally. There are many comments that have been written on the channel and these are live comments. I am mixing the total number. I am using a random number generator to generate a number, and whoever is lucky is getting their questions answered. That's what I can do. That's the best I can do. So, okay, let's go to the random number generator. 58. Okay. 60, 59, 58. This is the one. So let's take Neeraj Kothari. Okay, next question from Neeraj. I have two sons, 18 and 7. When we came to the UK in December 2017, the older one was 11 and the younger one was 1, 11, 1. Okay. If we apply for 7-year childhood through my younger one, 7-year child, if it is successful, then what will be the case for my elder son? Yeah, so firstly, you are assuming that it will be successful. That is fine. I'm not going to get into the merits of that. That is a completely different discussion. Your question is very specific. If one of your son gets leave under the private life under his own rights, since he is not born in the UK, it will be very difficult for someone who is not born in the UK, unless there are really exceptional reasons, the formative years are spent in the UK, etc., etc. You will need considerable evidence, and it will be at the discretion. It's not a straightforward application. Straightforward application is only for individuals who are born in the UK. So that's the first side of it, just to help you out. The other one who is aged 18 now, if he's already 18, there will be another discretionary application on the 18-year-old to ask for discretion. But if he's turned already 18, it will be a difficult one for him to join the younger one and become a dependent on them. The parents can, that's not an issue, but the one who is already turned 18, he may have to file some other application in his own right. So it is, since he has already turned 18 years of age. If it was under 18, it's quite straightforward. The whole family gets a dependent on that one main child who is getting the 7-year ILR. So that is my summary answer. Okay, no member questions and no super chats at this time. Okay, next question, 1 to 76, 59 immediately after. Good. Thank you so much. So the next question from Dr. Joy Burrows. Thank you so much for your guidance. I watched your videos religiously. Thank you. They were really helpful. My spouse visa was approved today. I applied category B. Congratulations on the approval. I think you watched all my videos and finally you filed your own application. Yeah, so that's what I tell you. Yeah, there are many things that you will end up saving. Accommodation reports which are not required, family and friends statements, affidavits, all those things are just nonsense. Everyone else is selling those, making money. But yeah, I have busted all those, and I have made all those videos on, do you really need accommodation report, do you need, etc., etc. So just anyone who is watching this channel now or after it's recorded and saved, yeah, so this is a clear result. I'm reading a comment from some viewer, Dr. Joy Burrows. Thank you so much for the guidance. So I think he asked questions previously and he also watched several videos on the financial requirement and all of that for the spouse visa. I watched your videos religiously and they were really helpful. Thank you very much. So if you do that, it will help you. It will at least increase your level of knowledge. There are many videos that I have made on the subject matter also. My spouse visa was approved, so his spouse visa is approved, and I applied under category B. Okay, thank you very much for informing, and best of luck. Reply. Yeah, this one is sorted. Okay. $11, 12, 11. Okay, next question from Windswept Canadian. Has this amount changed now that the basic income requirement has doubled plus April 2024 from April 2024? How to meet the financial requirement with savings indefinitely to remain? Yeah, so the question is on the financial requirement. So to give a background, firstly, the financial requirement for spouse visa, anything under the family route, spouse visa, parent visa, etc. If you're applying under the 5-year route to settlement, you are required to meet a financial requirement. Currently, that is 18,600 for the main applicant. It is going to increase to 29,000 from 11th of April 2024. So a month from now. So the question of Windswept is on that. Has this amount changed? His question is on the video, how to meet the financial requirement with savings. So in that video, I've explained how you can meet the indefinite leave to remain financial requirement with savings. Sorry, I have to drink some water. Okay. So the financial requirement for ILR, if you're already in the UK on the current rules before the change, either on the spouse visa or an extension of that, and then you will be filing ILR ideally, then the change will not affect you. So if you are already on the spouse visa or on an extension of the spouse visa or partner visa, then this change does not affect you, 29,000 increase. However, who comes under the new rules and they enter the UK, and then when they are applying for indefinite leave to remain, their savings requirement will change. So as per the current 29,000, I will try to do the numbers. So 29,000 into 6 plus 16,000, 18,600 plus 16, 34,600. So 34,600 was the financial requirement to apply for savings with savings if you are meeting the financial requirement for indefinite leave to remain. That is the current one. But after the changes, yes, you are right, Windswept Canadian, the savings requirement for the indefinite leave to remain will also change. So it will be 29 plus 16. So it will be 45,000. So that's what my calculator is saying, 45,000. So that will be the minimum requirement. That is savings only. I'm not talking of income. Income is a separate calculation. This is savings only. You would need a savings of 45,000 held at least for last 6 months before the date of application of the ILR, indefinite leave to remain, on the spouse or partner visa application that you are making, or any family route under the 5-year route. So that is my answer, yes. Okay. I'm trying to see if I can do 11 viewers, fine. I'll try and generate a random number to do justice to live members also. Let me just count and do 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 13. Let's do one live question. Okay, number one. Who is number one on the live? Kitchen Jen. So I'm taking one live questions now. One live question, and then again I will go to comments and then back to live maybe. Kitchen Jen. Can I switch from graduate visa to skilled worker visa without the high salary threshold? High salary threshold. I'm not sure what you mean by high salary threshold. If you're referring to the 38,700 skilled worker visa minimum salary, that will be from 4th of April. If you are switching from graduate route to skilled worker visa with a high salary, can I switch from graduate visa to skilled worker visa without the high salary? I work in a restaurant. I am on a post-study. Okay, you're on a graduate route. What will be my salary requirement? To calculate the salary, I also need to know the hours of work. So if I'm assuming a 37.5 hour working week, that is the basis of all salaries for home office job codes, you'll have to proportionally increase that. But for a 37.5 hours working week, it would be 38,700 into 50%, 30,960. Yeah, so you will have to be paid at least 30,960 if you are applying for a new entrant category. From the graduate route, you can apply for a skilled worker visa of up to 2 years under the new entrant category. It will only be granted, you can only apply up to 2 years of, you only up to 2 years of course and 2 years of application also. If you apply more, it will be refused. So 30,960 should be your minimum salary, and you can apply on the basis of 37.5 hours working week. So that is my answer. So that one is also answered. Okay, I will take the channel comments also. Along with this, I will total up. So I have 14, 13 comments. That's 60. 4, 5, 6, 8, 9, 6. Okay, 61. I'll generate the random number again. 61. Let's say 27. 6 was a 24. 2, 3, 4. Four, 27. Let's take 1, 2, 3. Here it is. Okay, question from user FF9KN. Question is, I live in the UK for 5 years. I came in 2018 and I have pre-settled status. So this is a question on EU settlement scheme, looks like to me. Good. That time now I have been settled status. Okay. 5 years, came in 2018, 18 plus 5, 23. Okay. Pre-settled status, that time now I have pre-settled status. When applying settled status, I give my parents residence in UK, but I live 5 years after the application. Last step, they ask me, prove you live in the UK. I give all my evidence and my parents' evidence. Is that okay on my application? Yeah, I think you are under 18 or you are living with your parents. The children's applications are a little bit complicated. I know you may not have letters from the school or university or anything like that. Try to get whatever evidence to prove you were living in the UK. Parents' evidence, it's not given that much of a weight, but yes, you can include your parents are also living in the UK if you are living with them. But in your own case also, you need to prove that you were doing something. I understand if you are under 18 or something, you may be studying, etc. So maybe letter from a school or something, or your transcripts, any degrees, education, diploma, whatever you did, enrollment letters, get confirmations from universities, colleges, wherever you have studied, whatever you have done. So you will have to prove something to show that you were also resident in the UK. With under 18 years applicants, it is slightly difficult to get normal evidence, which is like council tax bill, bank statement, etc., and all of that, pay slips and all. But yeah, you should give whatever you were doing. You were studying, give anything relevant to that. If you're working from 16, also between 16 and 18, or whatever is your age now. So yes, you will need some evidence. Parents' evidence may help, but that is not conclusive. You will have to give some of your evidences also. Okay, next question. So we have Stephen, generate 43. It's 6 of 48. 1, 2, 3, 4, 5. This one. Question from Ravindra. Ravin. Okay, I'll just call you as Ravin. If my name is messed up in my course, okay. Family name under given name. Okay. But all spellings correct and all names included within course, will my visa reject? If there is a mistake on the course, it is quite common sometimes people or employers make a mistake in the passport number, names exchange instead of a name. Yeah, so first name, last name, and all of that, spelling mistakes. Your employer or whoever has the level 1 access to the SMS sponsor management system, I should ask them to go into the sponsor management system, open your live course, and put a comment over there saying full name. They don't have to write too much, just give the correct whatever the name is, first name dash X, last name dash this. So that is more than enough. The caseworker will look at the comments first, and that the comments will override anything that is filled on the form field, on the name field. So that is what you should do. Ideally, yeah, that is good practice. That should be done. I cannot tell you about rejection and all of that, because that is what is ideally expected. If there is a mistake on the course, the level 1 user is supposed to go in and make the changes accordingly. So if you see the mistake, whoever sees it should raise it. So you are the applicant, you should raise it to your employer, and whoever is dealing with the sponsor management system, whoever has the level 1 user access, they should go into your course, put the comment with the correct details, and those details that are mentioned on the comments will override anything that is filled on the course. So that is the answer to any mistakes rather on the course, not just this one. Yeah, so next question, 22. 7, 6 of 40, no, 22, 6, 4, 6, 1, 2, 3, 4, 24, 1, 2, 24. Okay, reply this one, Mad World 9186 9816. Hey sir, can I change my student visa to work visa after completing my foundation degree? I am now on foundation degree, which leads to bachelor's. Can I switch it after completing my foundation degree to work visa? Foundation degree. I remember I have done at least one switching from foundation degree directly onto skilled worker visa, but that was last year. What were the changes after that? You should have completed. Yeah, in my opinion you should be able to do it, because on the foundation degree course usually I have seen that on the CAS that your goal is to go, but then foundation degree in itself is a degree which is independent of anything in the future that is promised. So that has a course start date and course end date for that degree itself, foundation degree. So you should be able to switch into the skilled worker visa. That is my advice, that is my guidance. I cannot advise on individual cases unless I am instructed as an acting lawyer, but yeah, that is what my advice is, and I have done it once. I remember someone switching from foundation to skilled worker. Okay, so next question. I'm using a random number generator. I'll do one more comment. 19, let's say 19. 6, 3 is 18. 2, 3. 1, 2, 18. Here is 19. Okay. So the question from NVIDIA, I am skilled worker permit now and with my family will new rules affect me? I have been for past 5 months been here. No, NVIDIA, it will not affect you. The rules are changing now, so it is this point forward. Any application which is filed, skilled worker application for the main applicant that is filed on or after 11th of March 2024, only they are affected. So if you are already working in the UK for past 5 months, then definitely you have the skilled worker visa already under the previous rules. You can bring your family members. Your family members are not affected. That is perfectly fine. Okay, next one. 17. So this was 19, 18, 17. Okay. Sanjay Raja. Question is wrong information. Okay, okay. What is the point? Okay. This is wrong information. It is clearly stated that you are already on skilled worker visa. If you change employment or renew or extend, the requirement does not apply. It is not stated anywhere. The rules are not published. Yeah, so just stay away from individuals who are not qualified to give advice and they write such comments. That is not correct. You can go into the skilled worker immigration rules fact sheet which came around February. Over there, Home Office has clearly stated that at the point of any future applications, if you're already, so the individual is trying to raise on the 38,700 salary requirement. Yeah. What is the, so the situation is any applications that are filed on or after 4th of April 2024, they will have to meet the new 38,700 salary requirement. So if you are already in the UK on a skilled worker visa with your whatever current salaries are, and whenever you go to extend or do any subsequent application, you change employer, you extend or you apply for ILR, you will be expected to be paid the new salary requirement. That is correct. That has been stated in the fact sheet. It will shortly come in the rules also. Don't worry about it. The rules will be published very shortly. We are on 12th of March, 4th April, the rules will be, anyways, they will apply. Before that only the statement of changes will come. I'll make a video on that. So that is perfectly fine. Yeah, these comments help people pacify themselves. I think that's why many people read it and like them, but that is wrong information. So I am a qualified immigration advisor. I have professional indemnity. I have a license to practice. I'm not going to give wrong information on this channel. Okay, anyways, I have taken it. I have liked the comment also. Very good. Let's do next one. 45. 45, 6, 6, 7, so 42. Okay, 1, 2, 5, 6, 7, 42, and let's, okay, this one. Hello sir, I forgot to submit land registry. Okay, this is a question. I just uploaded my passport bio page copy and a letter from her. Upload her title deeds. Will my visa be refused for this reason? My other complete. I'm married 3 years, general relationship. Okay, this question is on the accommodation requirement for the spouse visa or partner visa. That is under the British Immigration Rules Appendix FM. So the one of the requirement is for the accommodation if you are giving. I think it is there in, there is another video on the list of documents, and there is also a list of documents to be downloaded on our website. I think you use that, and from there, but then you forgot to put your land registry. I don't think that's the end of the world. In the immigration rules there is a provision, the caseworker, if they require the land registry, they can do the search themselves, but even if they do require it, they will write back to you saying we need that accommodation undertaking or something, and then you can provide that. I see that. I don't, it is a 50-50 chance whether they may it will not be refused. It's highly unlikely, because in the rules it provides that they will usually ask for it if it has not been given and if they want it. So 50% chance they may ask it, 50% they may also approve it without that, because they can do a search. You have given a letter from the owner of the property, your mother, etc. So I think you should not worry much about it. Uh, since you already enrolled your biometrics, yeah, I can understand that, but I think you should be fine. That's my opinion. Okay. 61. Okay, let's generate 50. 2, 3, 4, 6, 8, 9, 6, 54, 53, 52, 51, 50. Okay, so another question I see is, sir, is there any delay in visa approval? I applied for dependent visa on January 29th, but still no reply. Dependent visa on 29th of January. I'm assuming that the main applicant's visa is, everything is fine on that. There are no exceptions over there. So usually your decision should come out. If it's an outside UK applications, usually decisions come in 15 working days. It's about about 3 weeks or so if you're putting calendar days, but yeah, so 3 to 4 weeks should be the standard decision time for a dependent visa outside the UK. If you are applying for a dependent visa inside the UK, standard processing is about 8 weeks. So I don't see any reason why they are delayed. If there is some issue, I don't know what is that. They are trying to investigate the relationship, whatever that is, or the main applicant's position, whether they have a job, sponsor is approved, or any issues with that. They may be investigating that if it is too much of a delay. But from 29th of Jan, if you have applied from inside the UK, 29 Jan, 29th of, then you still have time for the 8 weeks period. From outside UK, it takes about 3 to 4 weeks, and you should get a decision. If you have not got a decision, maybe use that UKVI contact phone number. You have to pay, I think, 1 or 2 pounds for that, and raise a query through them. They have some channel where they raise it to the caseworker and try to get an update. But there is no guarantee you'll get an answer, but that's one of the ways to trigger an action or a decision on the application. So you can try that, like it, and like it. Okay, let's do another random generation. 18. So 12, 14, 15, 16, 18. Okay. So it is the same question I've answered below. I think this one is like, then visa, skill work visa, be for 5 years, maximum, for example, it's 5 years. Okay, so the question is clarified further. New entrant skilled worker visa, if you are switching, for example, if it's 5 years, could you also explain after 4 years the skilled worker migrant salary will be required to increase to the normal salary, not the discounted salary? Yes, you are right. So the question or the comment is, question along with the comment is, if you're on a graduate route and you switch on to the new entrant category skilled worker visa, you will be paying a lesser salary, 80% of whatever the minimum salaries are, currently 26,200, and after the change on 4th of April it will be 38,700, will 80% will be 30,960. So if you are paid 30,960 after 4th of April and you apply for a skilled worker visa, you will be given a 2 years of skilled worker visa. 2 years only you can apply. So remember that if you are switching from graduate route, and after the 2 years you will have to be paid the normal salaries at that point of time. So yes, you are right. After 4 years, the skilled worker, after not to. So if it's a student switching to the skilled worker with the new entrant category, they can get up to 4 years. So if you're a student, you're getting 4 years, and at the end of 4 years, when you're extending further the skilled worker visa, you will have to be paid the normal salary at that time. That is correct. Let's point. Okay, I will just take some. Okay, live viewers are gone anyway, so I don't think much. That is fine. How many live questions do I have? I'll just randomly take some live questions. So let me take the latest one. Namaste from London. I am on a dependent visa. Okay, so Namaste from London. I'm reading your question. I'm on a dependent visa and my wife is dependent student. I'm working in a hospital. You are a dependent, okay. And visa expires May this year. I'm getting sponsorship visa next month. Can my wife get dependent visa? Your wife will only get a dependent visa if she completes her course of study. She cannot switch from inside the UK if she has not completed the course of study. She will have to go back home to her home country and apply for an entry clearance if she has not completed the course of study. If she has completed the course of study, then she can switch and become your dependent, provided dependents are allowed in your category of job code, provided you are not in one of those job codes, care workers 6145 and 6146. If you are in those job codes, you cannot sponsor a dependent anyways. So that is my answer to the live question. Let me take another live question. Dietitian Kinza, I am on a new entrant study visa, just ended 1 month ago. If my employer pays 38,700, we apply new entrant discount. Can my dependent stay then? Okay, let me think. So I am a new entrant, my study. I am a new entrant, my study just ended. Okay, dietitian Kinza, yeah, I see you are live. Okay, I'm trying to get your question. So I am a new entrant. So my study just ended. So you are on a student visa, you just ended 1 month ago. My employer pays 38,700, and we apply for new entrant discount. Can my dependent stay? If you apply for new entrant discount, you'll have to pay 36,960. Okay, can your dependent stay? It depends on the job code. If you are in one of those job codes, 6145, 6146, your dependent cannot stay because those job codes cannot sponsor a dependent. So your dependent will have to leave. If you are in any other job codes, then your dependent can. You are a student, she is a dependent. Your dependent can switch from a student dependent to a skilled worker dependent. So that is my answer. Okay, I'll answer Samir's question. Sir, I want to bring my parents in the UK visiting, but they don't have bank statement and payslips, but they have employment. Yeah, that is a common problem in many countries. You will have to show everything in the bank accounts and all. Your word will not be taken if you just give letters from everywhere stating that they are earning this much and that much. Home office, the way they work is they look at it as a UK system. How the way system things work in the UK, they are expecting that from any country that your parents are applying. So they will have to get the payments, salaries all in their bank statements, letter from employer, pay slips and all of that, pay the taxes on that income. Especially taxes is what they always care about. I've seen that. So you will have to convert that, wait for the periods of time, at least 6 months of documents will be required. More than that, maybe preferably a year or so, and then apply. But if you apply without any documents, it may be slightly tricky. So that's my advice from seeing of previous whatever refusals that I have seen. Hemant, I'm seeing your live. Please see my question. Okay, Hemant, where is your question? Okay, Hemant. Okay, I'm currently on a 5-year skilled worker visa, not a care worker visa. Can I get my partner next year with current visa, or new salary threshold need to be met? If you have a skilled worker visa already and that is valid, next year also it will be valid, then you can get your dependent, that you can get your family member. That is perfectly fine. So that is my answer to your question, Hemant. Samir, can I sponsor them and not show their employment? It will not work. Uh, they, the way the Home Office rules apply is they don't care what the sponsor's income or financial standing is in the UK. They care more about, they will always look at their own personal circumstances, your parents. And yeah, that is one of the things. You cannot just use your documents. They need to see their financial circumstances as well. Dietitian Ginza, but if the salary threshold shown 3700, even then job carer can't stay. Yeah, the salary threshold does not matter. The immigration rules say if you are sponsored in one of those job codes, that's the end of it. It doesn't matter what salary they are paying. They may be paying you 100,000, doesn't matter. So it depends on the job code. The job codes cannot sponsor dependents. Kate Harrison, for a skilled worker visa, do I need to upload my CV, university transcripts when during the process is job at the appropriate skill assessed during the course visa application? Do I need to upload my CV, university transcripts and all? You upload your documents when you apply for the skilled worker visa. For the course, for the during DCOS, I think you mean DCOS. Yeah, for the DCOS, the employer has to give whatever evidence they have, how they found you and all of that. But you have to upload your completion of course if you are using that university transcripts, degree and all with your application. Okay. Thank you, Hemant. Yeah, it saved you 40 pounds of your solicitor. Definitely consider becoming a member here. It is much cheaper and you can ask any questions during lives or even on the comments. That will turn out to be much cheaper. Okay, look at the membership options. They are I think 5 pounds or less maybe. Thank you, Samir. Okay, that is done. What next? What next? Anything else? Okay, I will take some questions on the channel. Do I really need to? Let us see. Applied 1, 2, 3, 30. Okay, kitchen is done. I'll just answer some of these live questions. I know some of them have left. That's fine. You can watch the video later on. Can we transfer our skilled worker visa to self-employment within UK and sponsor ourselves? No, you cannot do that. Please tell me about the graduate route and salary threshold. Graduate route. Yeah, for kitchen, I think I've already answered it. You have to be paid at least 30,960 to get a new entrant category skilled worker visa of up to 2 years by switching from graduate route to skilled worker visa. Okay, Samir's answers. When is started next ballot for mobility? Sorry, no update on that. Arul Johnson, can be the short term 1 year. Went to India. Okay. Yes, Kate Harrison, you have to put your documents when you apply for the skilled worker visa. Yeah, the DCOS is applied by the employer, so they have to give whatever evidencing they have to. Okay, how long has it been? Okay, I'll take some more questions on the channel. Let us see how many do I have. 2, 3, 4, 5, 6, 7, 66. Okay, Samir, your question is your friend has a family private life visa, family private life. What was the basis of his visa? Why was he given that? Can he and her partner, can he and his partner who have been together for 5 years, can they apply for human right application? So overstay. Yeah, the overstay person will not be able to make an application from inside the UK. There may be some possibility, there may be some application, definitely. It's not that the end of the world. If the relationship is genuine, preferably they should have cohabitation evidence, living together evidence of at least last 2 years. Speak to an immigration lawyer, get all the evidence and information assessed. That is the best advice I can give. If they have 2 years of living together evidence, that may help. If they don't have that, if they have any plans of getting married, but the application can only be filed from outside UK, because the overseer person, they may not be able to switch unless there are any exceptions. There are very small area of exceptions, but yeah, so the applications are quite expensive, so consider it properly before applying. I don't think the person can apply from inside the UK, but I will need to take the lawyer, whoever lawyer you, immigration advisor you are speaking to, they need to take all the information properly and then advise. But briefly speaking, the overseer may have to make an entry clearance application, provided they have at least 2 years of cohabitation evidence, or if both of them get married, then it would simplify everything. That's my brief advice. Okay, 66. Let's take 13, 12. Okay, the question from Mohammed. Working an expedition, my file, I'm not sure about that one. Okay, we have applied for skilled worker visa through a solicitor. So the question from Mohammed is, hello sir, we have applied for skilled worker visa through a solicitor few days back, but she said that we are waiting to get costs from home office. Skilled worker visa applied without a cost, okay, pending cost since January, but we would but we would but we are going to attach a supporting document with the application form. Please let me know what are chances of getting positive decision on the file. I am very much worried. So yeah, pending a cause, I know many lawyers may have filed this, individuals may have filed this applications because of the changes. It is a 50-50 chance that Home Office may positively consider it. They have the option to go strictly by the immigration rules and refuse the application without a cause. That is possible. They can do that because the immigration rules allow them. The immigration rules clearly say that you need to have a valid cause on the date of application, which has been issued in the last 3 months, which has been assigned to you, and there is no valid cause on the date of application in your case. That is one side of it. Secondly, they may exercise discretion, keep it on hold. In my opinion, if you are trying to get the benefit of the rules change and you're trying to bring dependents or something, and that's the reason you filed earlier, then Home Office may or may not. There is about more chances, 80% chances that it will be refused if you are just trying to get the benefit of bringing dependents or allowing dependents and all. But if you have a genuine case where I understand cost is delayed, all causes are delayed, and your visa was ending and all of that, you didn't have much time to apply, then they may exercise discretion and decide it in your favor. Consider the application as valid. So those are two possibilities that I can think of. Thank you, Samir. Okay, let's mark this one. Okay, I'll take some more questions on the channel. Let's random generate 52. 2, 3, 4, 5, 6, 7, 8, 9, 10, 10, 60, 54. 52. Okay, this one. Question from Arjun Patania, 9706. I am on spouse visa in UK. My wife's study complete. June 2024. I don't think you're on dependent visa. After that, I apply sponsorship in care home. So you applied for. So dependent, PBS dependent applied for to switch to skilled worker. Can I live with my wife, and what is salary package? Please tell us. Sorry, it's old students. Okay, so you are a PBS dependent and wife will complete her course of study in June 2024, which is yet to come. So in that, let me have a think, 1 minute. So PPS dependent switching to a care worker visa. Can I live with my wife? So you will become the main switch. Yeah, PPS dependent, as since you are dependent of a student, you can switch to the skilled worker visa anytime. So if you switch after June 2024, then your wife can also become your dependent from inside the UK. So you will apply for the skilled worker visa, she will apply for the skilled worker dependent visa. What is the salary package? So it really depends on what type of work you are doing. If you are doing any care worker related things, whatever salaries they come as per the immigration salary list that is going to be published and all, there will be some discounting. But usually by default, if you are getting a normal job which doesn't have any discounting options, a student switching to a skilled worker visa, no, it will be better off if your wife switches to a skilled worker visa, because she can get a job with a lesser salary, 30,960, under the new entrant category, because a student is switching and she can get up to 4 years of visa and you can continue to be her dependent. But if you switch, you will have to meet the normal requirement of 38,700. I'm not taking any discounting of shortage and all of that, but for a standard occupation, 38,700 will be your minimum salary required. Okay. Okay, Shamik, your question is, if I get a skilled worker visa and after 2 months if I get a new employer with skilled worker visa, if I get a skilled worker visa after 2 months, I get a new employer with a skilled worker visa with new initiation, can I do that? Yes. So if you switch to a skilled worker visa today and then you again switch to, so you switch to an employer A today and then you find employer B after 2 months, you can switch to employer B. That is perfectly fine. You can change employers as many times as you want, but every time you will end up making a new application. That is the requirement. Okay. 51. The question is from Priyanka. Hi sir, I'm waiting for cost since November. I'm under 6146, but my sponsor is regulated by Ofsted, not CQC, and disability children, so I get a visa. Yeah, if you apply for a skilled worker visa after the change, when is the change? The change has already happened yesterday, 11th of March. I don't think, as per the immigration rules, you may not be able to get the skilled worker visa because your sponsor is not qualified. So it's the date of assignment of the course. So if your sponsor who has assigned the course is not regulated by CQC, they may not be able to sponsor you. Yeah, that is my guidance. Yeah, Shamik, can I get refund of the IHS fees? Yes, you will get the proportionate refunds of the IHS fees. Yeah. Also, how long can get? How long can someone get their immigration history? From this, so Samir Baral's question about, I think you are asking UKVI subject access request. I think usually up to 5 years they definitely give you. They can give you more than that also. I think up to 10 years or so they may be able to give it. But most of the immigration applications they can easily give it. If you ask other things, they may or may not have it, like landing cards or anything. But thank you, Shamik. Okay. Next question. Let's take something 4 concurrent viewers. Number 4. 1, 2, 3, 4. 10 millionaires. Okay, what if someone have care worker visa? The question from 10 millionaires. What if someone have care worker visa from 2022? What's the rule? What's the rules for them? Can they still sponsor their dependents after rules change the same salary? Yes. If you are in the care worker visa category since 2022, you can continue to sponsor or sponsor your dependents. Yes, that is possible. Next number 65. Okay. Question from user ON8. I'm on a skilled worker visa in a care home. My company license got removed. I want to change my sponsorship. After changing sponsorship, can I bring my dependent? Let me think. I'm on a skilled worker visa. Okay. Yeah, I think I've answered this separately also for someone else. So since you already entered the skilled worker category, care worker category before the rules change for the dependents, even if you change employer now, I know your current employer. So the question is, your current sponsor, you are already on a care worker visa before 11th of March and your employer lost license, you are going to change employer. With the new employer, you are asking whether you can bring dependents. Yes, you can, because you entered the skilled worker category before the rules change. The category of the rules matters. You can change as many employers as you want. That's fine. To get the immigration history, Google search for Samir, the live question I'm answering. You should search for UKVI subject access request and just follow what that web page says. There is a form to fill up, there is an attestation of the passport or something to be done and all of that. We provide that certification of the passport copy on all of that. You can contact us if you want to do that, or any other lawyer can do that for you. And that's it. UKVI subject access request. Google for that and it will give you all the information. So 66. How many do I have? 2, 3, 4, 5, 6, 7, 8, 9, 10. 42. 6 4s are 6 7s are 42. 2, 7. Okay, next question from Munawar Pasha. Is it true that shortage occupation list is closing? Yes, shortage occupation list will close. They will come up with a new immigration salary list. And you make a new ISL salary list video. Let them release the ISL salary and then I can make a video on that. It is an impact on IT sponsorship job. I'm not sure. Yeah, so it has not been published yet. It is still in discussion. So once we see the list only, then I can comment on it. Thank you, Samir. Okay, next number. Number 4 is done, I think. Let's take this one. Okay, next question. Hello, sir. I want to apply for undefined visa. Can you help me for that? Sorry, there is no such thing as undefined visa. The undefined certificate of sponsorship is applied by the employer and that is given to the employee, to you, and then you apply for the skilled worker visa. That is how it works. There is no visa called as undefined visa. Sorry if that is the confusion that you had. So we cannot help with undefined visa because there is no such undefined visa. Okay. Let's do a random number generation. 28. 6, 4 are 24. 24. 26. Okay, this one. Brown boy UK1, and student can apply for before 3 months of completion of course, get new entrant rule, and he failed course. Yeah, failing of a course is not an issue. That is already established fact now. I have done applications where individuals have failed the course but they have completed the course of study. The important thing to switch to a skilled worker visa from a student visa is that you should have completed your course of study. You should have attended your university, submitted everything. In spite of all that, you were a bona fide student, a good student, but still you failed. That is perfectly fine. That is not held against you. After the course completion date, you can start working on the skilled worker visa, and yes, you can apply. So the question from Brown Boy UK1 is, student can apply before 3 months. I think they can apply within 3 months. That's how I understand it, not before 3 months of course completion. And the work start date should be after the course completion date. That's number one. And get new entrant rule. Yes, they can get the new entrant visa because they are switching from new entrant. And even if they fail the course, yeah, that would be fine, because the failing of the course is not a condition, precondition or a post condition that you have to pass it subsequently. Even if you fail, but you should complete your course of study. That is what is important. So in other words, your university should not report to home office and cancel your student visa. If that happens, then you are not completed your course of study. That's how I would put it. Next, 24. So 27. I'll come to the live questions. First, let me cover some of these random numbers. I did 24, 2, 3, 4, 24. Okay, the question is from Viha Patel. If my job code is 6145 or 6146, that is the care worker job codes, but my salary threshold is 29,000, then I can come with my dependent after 11th March. No, you cannot. The job, if you are on a job code, one of those 6145 or 6146, you cannot sponsor the migrant, irrespective of whatever you are paid. You can be paid 30,000, 40,000, 50,000, doesn't matter. Salary is not a question in that particular area. I'll take Toby Trust's live question. I switched to work visa on March 6, 2024. My dependent visa is yet to apply. I switched to work visa on March 6. So if you are not on the any of the care worker job codes, anyways the changes don't affect you. Assuming you are on the care worker job codes but you applied on 6th of March, which means you submitted your skilled worker application on 6th of March, your dependents can join you subsequently. That is fine. You can apply for your dependent's visa. She can join you because your date of application is before 11th of March. So first day. Hello sir, I am in student visa. I'm going to apply for graduate. So I'm taking the next live question for Steve. I'm in a student visa and I'm going to apply for graduate visa soon. 2 times I got 20 hours and 20 minutes payslip from my employer. So break miscalculation is you. Yeah, I think 20 minutes will not be that much of an issue, but try to be within those limits. I know that Home Office has curtailed visas where individuals have straight blatantly abused the hours of work. Instead of 20, they are working 25, 30, whatever that is. So don't do that. I think the 20 minutes of overwork may not, I think home office will be reasonable and they will exercise discretion even if they do find this out. But it should not happen on a regular basis. Make sure that tell your employer you work less. You can work 19 and a half if you want to, but try to avoid that. But I don't think just one pay slip with the 20 minutes of excess should matter that much. So the next number I have is number 39. After 5 minutes or so, within next 5 minutes, I will end this live. If you have any live questions, do ask me now. Thank you very much, Dave. Do subscribe to our channel. Like, consider becoming a member. Anyone who is live or listening to this recording, I'll answer some more questions. Yeah. 39. Okay. How do I find 39? Yeah, maybe last one question, 1 or 2. 6, 6, 36. 2, 3, 4, 5, 6. 39. University withdrew my course and visa, so I couldn't complete my study now. They gave me 60 days to leave or switch. Can I switch to skilled worker visa? No, you cannot switch to skilled worker visa because you did not complete your course of study. So the question is, university has withdrawn your course. Yeah, you got the 60 days to leave. You got the cancellation notice email from home office. You cannot switch to any visa category inside the UK except any family route. I don't think that is your case. If you have a spouse or partner who is a British or a settled person, then that is different. But I don't think in your case, you are just a student by yourself. There is not much that you can do. 11. Okay, the question from Ali Raja is, please clear, it's on the care worker visa changes that I have made the video. That is a viral video. Please clear how to apply for course before 11th March or for visa before 11th March. You have to apply for the visa, the skilled worker visa before 11th March, latest by 10th of March to come under the previous rules, not the course, the skilled worker visa. And yeah, just to add on, anyone who is live or anyone who is listening to this recording, if this, I know there are many questions coming on the channel. I have scheduled the lives weekly, once a week, usually on Tuesdays. So if I get 100 likes to this live, then I will schedule another live during this week. I will try and jot out my time. Yeah, if I do get 100 likes only, then I'm going to do that. That's just an additional thing that I will try to do because there are many questions coming. So if I do, I encourage everyone, if you do like, if this video has helped you live or anything, do subscribe to the channel, at least like this video. So I will get to know whether it is adding any value or not. I think there is a live question. Toby Trust, as a student who wants to switch, I'll answer this last live question. As a student who wants to switch, does my employer has to give me a new employment letter after? Student who wants to switch, does my employer has to give me a new employment letter after the course? It is always better for the employer to give, it is advisable to give a new employment contract when they are sponsoring. So you are already working as a student with that employer, and then you will be sponsored by the same employer under a skilled worker visa. You should get a new contract of employment. Obviously your hours of work will change, your salaries will change, everything. Definitely you should get a new employment contract, employment letter, contract, whatever you call it. That is advisable, that's what you should do. So, and yeah, so anyone who is live, who is watching this live, if any information has helped you, any of your comments have been answered, it has helped you, saved you time, money, efforts, anything. Someone just said they save 40 pounds for lawyers consultation. Yeah, there was a comment. Yeah, so if it has saved you money, maybe whatever that is, do at least like the video, subscribe to the channel, consider becoming a member. If I get 100 likes to this video, I will schedule another live during this week only. But by default the normal live will be next Tuesday. So do like this video. I'm looking for 100 likes to this video, and thank you very much. I will be ending this live now. I know there are 6 concurrent viewers. Thank you very much whoever is watching this, and end stream.